Thank you so much. Thank you so much for having us here today, last panel of the day. And we speak about regulations. We have a power pack panel today, and I am conscious about the timing. So I'll quickly start. To set some context, we have been hearing the good side of the story, which is Startup India Fund of Fund committing 10,000 crore, RDI committing a lakh of crore, RBI easing out regulations for regulated entity, investments by regulated entity in AIFs. And we have been hearing stories about pension fund, and which it was all over the media today that once it opens up, 17,000 crore of corpus will get committed to AIF. While this is the good side of the story, over the course of 2 days of conclave, we have been hearing from the regulators, we had SEBI officials coming and speaking. One thing has been the ground rule for them is, I will give you a conducive environment, show me some governance around it so that you attract more. I'll ease out regulations more for you, but ensure there is a governance. We have seen regulatory changes in the last while. It has eased out, but there have been certain regulatory changes. So the topic remains for today is, while there are regulatory changes, let's understand from the experts today, can it be used as a leverage? So let's start with the hot topic of the day today with you, Bharat, Press Note 3. Your take on Press Note 3, and do you think it clarifies what it intended to clarify, or it complicates or leaves something in a gray zone?
Yeah, no, thanks. Sorry, my audible. Yeah, I think I'm audible. So, no, thanks for that. Look, I think I just want to call out a big thanks to IVCA in particular, and the DPIIT, the PMO, and for the efforts that were made to actually get this clarification going, right? I think we have to be grateful for the fact that a lot of the gray areas in relation, I mean, we have to look at it contextually, right? Where are we sitting? We're sitting at the IVCA conclave. The whole idea of, the IVCA shepherding this clarification was in the context of, how it relates to LPs. And I think in that context, it's been hugely helpful, because what's happened is that to the extent you have a fund, and you're up to 10% of China investment in that fund, I think it's quite clear that, look, non-controlling beneficial ownership will be exempt, and that really helps it. Are there some gray areas? I think there are gray areas to the extent you might talk about direct investments. If you're sitting out of Shanghai and you want to make an investment in India, I think that's probably not, the intent is not to go that far. But I think, the precipitators of the regulatory clarification weren't aiming at that. That's a wholly different sect altogether. So, and I think this is going to have a huge impact, right? Because when you look at the reverse flips that were happening back, and you look at fast track, and you look at deemed approval, for those fast track mergers, there was always this issue about, is this within the automatic route or not if shares are being issued? So I think a lot of that clarification has come. It's also clear that, look, you look at it, in terms of a per LP basis. So if you have a pooling vehicle or you have an SPV, you've got to look at each individual investor. And even if you have more than one LP, which is, say, from a LBC territory, as long as it's within the 10%, that's exempt. So you're not sort of creating an aggregation or a cumulative test. And I think at least that's quite clear from my reading of it. So where it really mattered, I think the clarification is helpful. And, hopefully it means the deal timelines get crunched, and, that's going to be positive for the ecosystem.
Thanks, Bharat, for this. From the tax side, Subbu, we recently had the budget, few hits and misses, and your views on it, please.
Yeah, thanks, Leela. Budget seems like a long time ago, given some of the things that have happened since then. But I would say that, I think increasingly as a tax practitioner, I started to now strongly believe that, budgets have become increasingly non-events, for the fact that, they become fairly boring. There isn't change, at least to the negative. Most times you get into a budget day, worrying about, especially for the investment community, what's going to happen to capital gains tax regime, our tax rate's going to go up. We, of course, went through that shock a few years back. There is always a murmur around increase in rates, which luckily didn't happen. So I would say the budget overall was, on the tax side, you did talk about some of the policy initiatives, which are, I think, fabulous for this sector. But on the tax, just the headline tax rates and some of the tax policy framework around it, I think there's a bit of stability in it in the last few years that we've seen, surely. But having said that, obviously, ye dil mange more. This industry is, IVCA does a stellar job of pushing several initiatives to make sure that there is a favorable framework, or at least a neutral framework when it comes to investing. And there are a whole bunch of issues that our ecosystem faces as they sort of go about doing their day-to-day business. So I would sort of call out some of the things that unfortunately have not yet come through, and not necessarily on the private equity side, but let's say on private credit or special situations investing. There is an ongoing ask which has not yet happened in terms of clarity around taxation of some of the income streams that such funds earn, which are business income in character. That's a key ask that's not yet come through. Category 3 funds, again, part of the IBC ecosystem, still awaits clarity on tax or a pass-through on tax. One of the big issues that we've all seen, and we're starting to see some emerging controversy on it already, is there's a lot of investing in public markets that happens. When I say public markets, I mean listed companies. There remains an unaddressed issue of how do you deal with, with the markets having run up, there are a lot of transactions that happen at rates which are below the market. Again, there's an ongoing tax issue around, how do you look at that discount that you bid at in the context of a listed market transaction. It's a very critical point to be addressed by the government. It's a market reality that, the market price is not necessarily, while conventionally a valuer will believe it's a true reflection of what the market value of a business is, but when market runs up ahead of fundamentals, you're not going to get a private equity investor to put in, market price for an asset that they buy. So, some of these are points that do need to be addressed. It's an ongoing endeavor, and hopefully we'll see some light at the end of it. But I would say overall, just on the budget, no news is good news is probably the headline. We had a buyback tax amendment, which is unhelpful. We'll hope to see some amendment before the budget becomes law. But keeping that aside, I think it was largely maintenance of status quo from a policy standpoint that we did see.
I believe a lot of work to be done on the tax side for the India portion. Kunal seemed to be smiling. I think it's raining gifts in Gift City. So your view on the budget for the Gift City, Kunal, please.
So over the past many years, right, the budget speech always mentioned something or the other that will be there for Gift City. I think this time, for the first time in the budget speech, we did not hear anything about Gift City, and we were like, okay, I think everything has come and we're not expecting else. But I think to everybody's surprise, what was there in the fine print was actually quite pleasant news for the industry. There are 2 or 3 big changes that have been proposed from the finance bill. One is that the entire tax holiday for any Gift City unit now has got extended for a period of 20 years out of 25 years. So which is a very big move in terms of how the current tax holiday works, and the new tax holiday is almost 10 years more that you are getting it. The second and important change is that what they have also proposed is that any tax outside the holiday period will be actually flat 15%. So this, if you really think about it, is again a very welcome move, because what was a lot of apprehension people had that after the tax holiday, if you have to pay the ordinary rate of 25%, 35%, then that's not something that people were willing to underwrite. And this now has become like, and that 15% is perpetuity, right, till they kind of again change, etc. So these are the 2 big change which have come. The only one condition that they have now brought in, at least for new units being set up, is that it should not have been formed by reconstruction and by transferring the business, etc. And that is what one will need to be very careful, that when they're setting up businesses which are kind of moving from India, etc., then how and what incremental stuff that is being contemplated to be done in Gift City, so that it does not be regarded as a splitting off or reconstruction of existing business.
Thanks, Kunal, for this. I'll come over to you, Pallavi. AI has been the buzzword in the tech world and also in the AIF world. Today morning, the chairperson from SEBI was here, and a number was quoted that from 600, it has moved to 2,181. Is it sufficient? Okay, she started smiling the moment I said that. And do you think, how will it pan out? Because we talk about sophistication, a crore of minimum ticket of 1 crore is retail. So does this sophistication of AI will help, or how will it pan out, and your views on it?
So I think nowadays the conversations with fund managers is moved away from which category will you opt for. It's become more sort of are you going to be the orphaned AIF category with literally no benefits, or are you going to be a AI only fund, which sounds very exciting? And then there are the rich, which is the LVF, because there all your investors are committing 25 crores now. And they are obviously AIs, and all of that is great, and they get lots of benefits. Now the middle category which has gotten introduced is the AI only funds. To give you some perspective and for the uninitiated, effectively what that means is you can now set up a fund which will have only investors who have gotten the accreditation as an AI. There are certain benefits which are being given to this category, which is quite helpful, in fact. One is from the last panel, term extension has always been a big challenge for funds. So the AI only fund has the benefit of extending the fund term for 5 years. The second one is which is a pain point for many fund managers, that they don't want to go and give the exam, the NISM exam, so they are exempt from giving this exam. The third pain point which we see particularly in negotiations with sophisticated investors is the huge list of asks they have, which then goes and sort of doesn't sit into the list of 10 rights which today we can vary per the pari passu circular. So the pari passu circular also doesn't apply to an AI only fund. And there are some other benefits as well that have been provided. But I think the larger issue has been the AI accreditation process itself, and we have had a number of conversations on this topic. For example, gift city feeders are not deemed accredited. Now they are trust structures, there are no binding commitments on day one, and therefore I will never be able to get an accreditation certificate for a gift city feeder. Most of the times we are now applying for an FPI license to qualify that vehicle as an accredited investor, which frankly speaking, given both the ecosystems should work together, it's a easy, I think, fix to allow a deemed accreditation for gift city fund vehicles. The second one is also around the way the net worth computation happens for organizations and the requirement to renew the certification. So I think if some of these things get eased out, then it will become easier to get the accreditation, and therefore it will be easier for fund managers to set up AI only funds and get the advantages that this category is offering.
Yeah, and to that point, Pallavi, in fact, today morning it was said that public information may be sought out for doing some auto, so there are portals being built in. I'm not sure, does it mean that the data will be picked up from income tax authority where you're given your amount? But having said so...
that's a big challenge when we have discussions with fund managers like on family offices, right? Many of them are sort of concerned about, the data going out and then, what kind of information is being sought. And it's not just restricted to family offices, it is another, headache. In a market where already raising capital is tough, you're putting another condition on an investor to go and not only do this once, but do this on a periodic basis. So if that process is streamlined, then a lot of the other issues, automatically fall into place. Like the AI only fund is great for, fund managers who are not looking only at a 25 crore ticket size. And want to give beneficial rights and want the benefit of 5-year term extension. So it's a great product. It's just the starting entry point of the AI part. If that can be streamlined, then this will take off in a meaningful manner.
Thanks for this. The topic for the day is compliance as a catalyst. So let's hear from Bharat. Over a period of time, how have you seen compliance becoming a roadblock or a non-negotiable item? And what's your experience in terms of evolving of expectation of compliance in the transactions?
Yeah, thanks. I think, my sense is that, if the target's hot and there are several people who are vying for that target, then really it becomes a seller's market. And I think in many processes, you've kind of seen that. For me, the holy grail is where, you don't have to rely on the whole stash of reps and warranties which we end up negotiating, and you say that, look, I don't need promoter confirmation. I don't need existing shareholder founder confirmation. I can actually go look at the data is out there, and get my comfort by doing my homework. And I think there what happens really is that there end up being several areas which are either problematic or become problematic in the pre-deal phase. And then there are some issues, compliance issues in the deal phase. So in the pre-deal phase, essentially you'll have issues around, essentially working out what's the cap table. There'll always be issues around people who may have had ESOP letters thrown at them, or some sort of MSOP, which is very poorly drafted early stage, and you're trying to work out, look, is there an entitlement or not? Do I need to chase this guy down for a waiver if he's no longer with the company, and so on. So you've got that sort of cap table, stack of issues which arises, unfortunately, fairly often, and then you've got to think about, should we restructure this? Do we move assets out? Do we do an asset deal and then a share deal? And so on. So you've got those issues. I think data, the whole DPDP compliance, which will happen in a couple of years' time, is going to reach a boiling point. And I think if you look at the sort of compliance that exists today, you have a policy, but whether our health tech guys and our fintech guys and all are really putting in place the systems to adhere and to comply, or that's going to be a work in progress. I think there's still work to be done, on that phase. I think the other sort of compliance issue which I see, at the point of deployment of capital is really in relation to antitrust. Because again, if it's a competitive process, whether you need a CCI or not, adds to deal timelines. And there, the underlying principle that if you're doing a minority trade with no control rights, is exempt, and therefore you don't need to make a CCI filing. I think that notion has really, the threshold for filing has really gone down. And even if you are at, say, sub 10% with no board seat, no observer, you have reserved rights, but no sole control over those rights. Those rights are, with investor majority thresholds. The CCI has still taken a view that, look, unless you have a clear, exemption available, that you need to file. So I think that's been a little bit of a headwind in terms of, an unfriendly aspect of trying to do deals. And so I think we find ourselves in situations where you're spending a lot of time really trying to get the CCI analysis right. And the CCI analysis is now cutting through if you have even mandatory conversion, say if you've got a private credit situation and there's a default and therefore there's a mandatory conversion happening there. That's not automatically exempt as well, and there have been CCI orders on that as well. So I think these are some of the compliance kind of issues that that need to be improved. I guess just to complete, even simple things like is there cash in the business and stuff like that, right? If you're talking about control deals, traditional sectors like manufacturing and all, getting that comfort is still a work in progress. I think those are areas where still work needs to be done.
Thanks, Bharat, for this. Let's hear out from Subbu on the next hot topic that we have for discussion, which is Tiger Fund. Your 2 cents on it, Subbu.
I don't know if I can give my 2 cents, but obviously I think few things, again to level set, I'm sure everyone in this room has probably seen, heard, analyzed the impact of the Supreme Court of India's judgment in the context of Tiger Global. I think we've had probably now a 20-year run where, since the controversy on the availability of tax treaty benefits in the context of Mauritius funds was, challenged in the early 2000s, not literally in the year 99 and 2000. The government obviously had to step in at that stage, did come in with a very emphatic circular that said, what are the circumstances that need to be met for a taxpayer in a jurisdiction like Mauritius, should get treaty benefits, which was challenged, and the government there, interestingly, was the respondent, and they had to defend that circular and, say that, okay, all of this is very much within the legitimate right of the Indian government to decide what kind of tax treaty and what kind of tax treaties we need to negotiate in the context of the country's needs. And, the Supreme Court, in a landmark judgment, which is the Azadi Bachao Andolan, obviously blessed the revenues action at that stage. And here we are, 26 years hence, and of course a whole bunch of controversy that, keeps emanating, at regular intervals, but courts have repeatedly, confirmed the Azadi Bachao Andolan and the Revenue Administration Circular of 2000, 789 of 2000. But so to that extent, Tiger Global represents a paradigm change in interpretation. It unsettles the policy that we've all within this industry as tax practitioners, legal advisors have been taking a view, for the last 2 decades. And that's the reason why, 2 or 3 things that fundamentally the court said. One, that, they've sort of looked at the evolution of tax policy in India. They've looked at how the Indian government has acted in terms of, renegotiation of tax treaties, introduction of general anti-avoidance rules in the domestic law, and so on and so forth. And the court, in its wisdom, came to a conclusion that, what applied in 2000 cannot apply in 2026. And we do need to update the view on how tax treaty and tax treaty entitlements need to be reviewed. And here we have a policy framework that now says that merely because you produce a tax resident certificate that a foreign administration has provided is not good enough reasons to, is not sufficient for you to claim treaty benefit. And India can go, or Indian tax authorities can go behind that TRC and look at control and management, where is the head and brain located, to examine whether a tax treaty benefit ought to be given or not. The second and the more important one is, in 2017, when the India-Mauritius Treaty and, the India-Singapore Treaty were renegotiated, there were explicit grandfathering provisions that were negotiated by the 2 countries, which grandfathered all investments that were made before 2017. So the understanding was that while prospectively India will get the rights to tax capital gains, you will protect investments that have already been made. And that's, basic fundamental promissory estoppel, because people have made investments and made, bets on the basis of a particular tax framework, and it's only legitimate that, if you make a significant change in policy, it should apply on a prospective basis. And the parliament and the administration repeatedly, even after that, confirmed that we do not want to tax grandfathered investments. We will continue to look at it under the old policy, so on and so forth. Again, the Supreme Court, based on a particular interpretation of the rules, comes to the conclusion that India never intended to grandfather, quote unquote, a tax avoidance structure, which again represents a big change. That's not the way that practitioners looked at it. That's not the way the industry assessed exit tax. And, we've obviously had the best years of exit in the last 4-5 years, and substantial gains have been realized on which taxes have not been paid based on existing interpretation. And the court has unsettled that. So while Tiger Global was given in a particular framework, fact pattern, unfortunately a lot of the observations that the court has made, which we believe are binding and cannot be disregarded, does change the status quo. And while not too many investments pre-2017 may still be in the portfolio mix of funds, given that, 9 years have passed, but having said that, Tiger Global does impact the past and exits that have already happened in the past, which is real concern, because, the statute of limitation in India is, whatever, 6-7 years. You can reopen cases, and there's a real threat that, the Revenue Administration could go after those old cases, could question cases where funds have bought from treaty-exempt investors, not withheld tax, relying on opinions, relying on existing interpretation. All of those liabilities could open. And as we know, in this industry, we are all operating with limited life vehicles, funds that have a liquidation period, they have an expiry date. And, we would not have provided for reserves or for, cash taxes to be paid if, they come on, with arrears. And the problem statement is also that, apart from taxes, you also have interest and penalties to deal with. So all in, I would say, this is a matter that is very, very critical for this industry. It is something which, again, IBCA is very, very actively working with the government to see what kind of formal clarity can be sought, because it's important. Because not just that there is a fear of what will happen or what the administration will do, but today all of us, the funds have to produce financial statements. If the current view of the matter of the advisor is that the particular structure is not going to stand the test of scrutiny, then funds need to start providing for taxes, need to probably hold back funds, so on and so forth. So I think all in all, I would say TG is something, the TG judgment is something that every fund needs to evaluate in the context of the historical transactions and transactions that they will do on a go-forward basis in terms of what is the realistic estimation of the risk that they, they're probably looking at, for those two categories of investments.
Thanks for this, Subbu. Another tax clarification, Kunal, I'll seek from you is the IT clarification on EAAA for 1023FB. If you can throw some insights on it, give some context and where does it lead to?
So the Edelweiss opportunity judgment, Leela, that you're referring to, I think it was a very positive ruling that came from ITAT. Maybe just to give you a little bit of context, the way currently a lot of these AIFs are set up is that you have the main trust, but people form separate schemes underneath the trust, and the registration, of course, is taken at the trust level, and there's a process of getting the scheme registered, or at least the scheme approved by SEBI. And what used to happen practically is people used to take PAN for each scheme separately, and the returns and all the compliances were undertaken at the scheme level. The current law, the way it is worded, is that the tax pass-through under 115 UB is granted to a trust with whom, say, a Category 1 or a Category 2 AIF registration has been granted. And I think the view among all the tax practitioners and the entire industry was that while the scheme may be operating as a separate unit, but it is still coming out of the trust itself. So the power to launch scheme per se comes from the trust. Just because there is a separate PAN does not necessarily mean that it is not a scheme which is under the Category 1 or Category 2 AIF for which SEBI has granted the registration. So what the Mumbai ITAT has done is exactly kind of reaffirm that position. Basically, it has reaffirmed to say that the power to launch schemes and operate schemes comes from the main trustee. There is no other governing document of the scheme. And therefore, merely because a PAN has been taken in the name of scheme is only for administrative convenience, it does not take away the fact that it is an AIF registered with SEBI and should be eligible to the tax pass-through benefit. I think the only one, maybe I would say, interesting thing that will need to be looked at it is that the reason why people also used to take separate PAN was to kind of give some bit of ring fencing from a tax perspective. But now if the view ultimately is that the entire vehicle is seen at the trust level where there's one PAN, then does that create a little bit of fungibility amongst various schemes which have been registered under that trust? That we'll have to wait and watch, but at least currently it's a very positive judgment because there was a lot of apprehensions, at least when people were setting up schemes, that will they be eligible for the same tax pass-through benefit or not, because the law only refers to a trust registered as a Cat 1, Cat 2 with SEBI.
Thanks Kunal for this. We move over to you, Pallavi. One size fits all approach cannot be undertaken for a compliance. I think that's a basic principle when we talk about AIF, and AIF is a very curated product. One of the circular which actually ended up trying to achieve was like the pro rata and the pari passu circular, which every category of scheme had its own nuance. Since the time it's been implemented, side letters have not stopped. You're negotiating a whole bunch of side letter. Your experiences on how are you navigating it and the issues that you are facing.
So I think first things first, I think the intent of bringing the pro rata pari passu circulars was, I think, a very good, because if you see across the board, there are different standards which were being adopted by different funds. Now, even for, right from the time of, reviewing an application by a SEBI officer, they are seeing in some cases unfunded, then NAV-based, and then funded, and then, many other permutation combinations. I think industry as a whole, at least in our experience, and I think as a funds industry lawyers, we can say that we have broadly seen Cat 1, Cat 2 go with, funded, unfunded commitment and capital commitment ratios. The Cat 3 side has operated more on the NAV basis. Now, I think there have been a few challenges on the Cat 3 side, predominantly because the NAV calculation for the purposes of drawdown is awaiting clarification, but I think the draft circular is already out in the public domain, so we are hoping that that comes through. In terms of, and it rightfully also clarified that, again, industry apprehensions about excuse and default scenarios getting sort of inadvertently captured. That was also clarified in the circular. So I feel like the pro rata circular, if the NAV clarification comes out, will be sort of, and the unfunded commitment also. Both are there in the public domain. I think it's just a matter of time. I think that kind of addresses the issues that we have seen so far. The pari passu one is, I think, where, again, we are often pushed by fund managers to include a lot of things in the side letter. We as sort of, the gatekeepers for, the regulatory side of things will often come back and say that, there are certain rights which do impact other investors and therefore they cannot be put into a side letter. So helpfully, there is a list today which is available of 10 rights. That being said, there are certain rights investors, particularly sophisticated investors, many of them are government backed, who do ask for certain rights because their policy demands it, or their own statutes ask for it, or just is their internal policy. Sometimes we find it a bit challenging to see whether it fits in the 10 list or it is something that can be read as a right which is not negatively impacting any other investor and therefore is okay to be put into the side letter. That's a call I think us lawyers are taking. But the good part is that circular also has the ability to increase the list. I know that there have been investors, particularly on the DFI side, who have made representations as well, saying that, these are certain things that our global policy mandates we take. So I think it's a fair proposition in terms of the law. If the rights are expanded, for example, I think one other ask often comes up is, why is an employee welfare trust, which is comprising of employees of the fund manager only, can that not be included? These are obviously, industry will always ask for more. And the best part is that the regulators have always been very, we have worked together on so many of these initiatives. And it's a work in progress. As the funds industry evolves, one side, there are sophisticated investors, they understand risk, they understand their rights. And then there is the other side of the industry where you are still raising retail capital. And you're not sort of, going down the very, sophisticated path of doing negotiations, making them read clause by clause. I mean, we know that doesn't happen. So I think it has to be a fine balance. Already there are regulations like the AI only fund, LVF, which SEBI is pointing you towards, saying that you set up those funds, these rights, these laws don't apply to you. So I think it's an evolving sort of landscape, but I think it's up to us also to do the gatekeeping and ensure that, rights are truly protected for the investors and the GPs in this tough market are able to raise the capital as well.
Thanks for this. We have paucity of time, so I will not dwell more on this, Pallavi. So before we wrap up, we have some, we can take few questions, but before we wrap up, a quick rapid fire. So first with you, Bharat, as we started, what is the major misconception people have about M&A lawyers?
Major misconception?
You negotiate indemnity too much.
That, we're insomniacs. I think we need sleep as much as anybody else.
Okay.
Hopefully we're not sleeping on calls.
Subi, with you, first adjective that comes to your mind, I will say a few words, first adjective that comes to your mind. SEBI. You have to be fast, 20 seconds.
Regulator. It's not an adjective.
Gift City.
Forward looking.
Budget of 26.
Non-event.
Tiger. I did not say fun.
Paradigm. I already said it.
Okay. Pallavi, bungee jumping or a negotiation on a table on any day, what would you choose?
Is it negotiation also like bungee jumping only? So I think I'm doing both while doing the negotiation.
Okay, Kunal, if AIF regulation was a movie, what would you name it?
I would say Lagan. And at the end, we say, Jeet gaye.
Thank you so much. We have 2-3 minutes. We can take 1 or 2 questions. Rajat, don't give me that stare.
We can take the questions outside.
Okay, we can wrap up. We
are around, so if anybody has any questions, we can You can fire away.
Pallavi knows what's going to come her way. So thank you so much. It's a wrap. Thank you so much for being a lovely audience and for your patience.